Brian Friedman is the head attorney for Justin Baldoni and the Wayfair parties. She claims that Brian Friedman is a co-conspirator in this smear campaign, she alleges, and believes that he has defamed her through his interviews where he defends his client. They had a hearing in that a couple days ago. The judge hasn't ruled on it, obviously, but Blake Lively's attorneys had filed yesterday a letter to clarify some things that they had said.
If you read that article, you took away that Justin Baldoni was a sex-addicted pervert, right? And poor Blake Lively had to survive doing a movie with him. She went to the press and tried to smear this man and ruin his existence by claiming, in so many words, that he had sexually harassed her. And she made him sound, with the help of the New York Times, like he was an absolute creep, a pervert, a sex-addicted pervert.
The legal battle between Justin Baldoni and Blake Lively has taken a dramatic turn following recent court filings that appear to fundamentally undermine Lively's central narrative. New documents reveal that Lively's own deposition testimony may have inadvertently demolished her claims of an orchestrated smear campaign, while simultaneously exposing the questionable tactics her legal team has employed in their discovery efforts. This development centers around a contentious subpoena dispute involving Brian Friedman, Baldoni's lead attorney, whom Lively has accused of being a co-conspirator in the alleged defamation campaign.
But in that interview, Megyn Kelly was sharing her unfavorable opinions, using some strong words and harsh language, but she's allowed to do that. Anyways, the Wayfair parties have now written a letter to the judge regarding this same subpoena to Brian Friedman's law firm. They're explaining why they believe it needs to be quashed, and they even have a quote from Lively's deposition in here. Now,
however, court documents suggest that Lively's legal strategy is rapidly unraveling, with implications that extend far beyond this individual case to broader questions about litigation abuse and the weaponization of the legal system. The dispute originated from Lively's allegations that Baldoni and associated parties orchestrated a coordinated public relations campaign designed to damage her reputation.
To justify the harassing subpoena, the letter erroneously alleges that Brian Friedman defamed Lively and that his conduct had amounted to public relations work rather than that of an attorney. It appears that Lively is slowly realizing there is no retaliatory smear campaign by the Wayfair parties against her. Too slowly, if you ask me. Consequently, Lively is shifting her focus to Liner Friedman in connection with her 14th cause of action, which alleges that certain Wayfair parties, through their attorney Friedman, purportedly defamed her via post-litigation statements to the media.
Central to these claims was Lively's assertion that Friedman, as Baldoni's attorney, crossed ethical boundaries by engaging in what she characterized as public relations work rather than legitimate legal representation. Lively's legal team served a subpoena on Friedman's law firm, Liner Friedman, seeking extensive discovery materials they claimed would substantiate their defamation allegations.
Published the entire, he said, nothing to hide, every text message sent between Blake and Justin and Ryan Reynolds, the world would have believed what she and the New York Times had worked on. It's a shocking case. People are going, oh, it's just like celebrity drama. No, this isn't celebrity drama. This is so much deeper than that.
This subpoena was part of a broader discovery strategy that has reportedly targeted over 107 content creators and social media users, raising significant concerns about the scope and intent of Lively's legal efforts.
We are talking about the corruption of the media who has the trust of the people. Like, you're an educated person, you read the New York Times, right? The New York Times essentially assisted in a hit on a man. For what reason? What did Blake actually want from Justin Baldoni? Publishing rights.
The controversy intensified following Friedman's media appearances, particularly interviews with commentators like Megyn Kelly, where he defended his client following judicial rulings that dismissed most of the Wayfair party's counterclaims against Lively. Lively's team characterized these defensive statements as evidence of defamatory conduct, setting the stage for the current legal confrontation. The most damaging development for Lively's case emerged from her own deposition testimony, which remains sealed but has been partially referenced in recent court filings.
And we got to read her messages, and she wanted to be put on the film, and she wanted to be put as a producer, executive producer, or else, right? You do this or else, threatening, so I'm not going to come back. Here are my demands. I mean, a total witch. Truly, that woman is possessed. I cannot, after reading those messages and Justin falling over himself because he was like, she's an A-lister, he was almost like pathetic.
According to Baldoni's legal team, when questioned under oath by Friedman, Lively admitted that the only ongoing smear campaign of which she has personal knowledge involves the counterclaims filed by the Wayfair parties against her. This admission represents a fundamental contradiction to Lively's public narrative. Her acknowledgement suggests that what she previously characterized as a malicious smear campaign may actually constitute legitimate legal counterclaims filed with proper factual and legal basis. The distinction is crucial from both legal and strategic perspectives. The court documents emphasize that counterclaims filed without retaliatory motive, reasonable basis in fact and law, such as the claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. This language indicates that Lively's team may have fundamentally mischaracterized standard legal proceedings as improper retaliation. Furthermore, the timing and context of Lively's deposition responses suggest that her legal team's discovery efforts may lack the substantive foundation necessary to justify their expansive scope. The court's inquiry into why discovery was needed from Friedman's firm when Lively already knew which specific statements were allegedly defamatory exposed a critical weakness in her legal strategy. Her inability to provide a satisfactory response both at the hearing and in subsequent filings indicates potential overreach in her discovery demands. The legal framework surrounding Lively's defamation claims against Friedman reveals another fundamental flaw in her litigation strategy. New York law provides absolute privilege for communications made by individuals participating in public functions, including judicial proceedings. This privilege extends comprehensively to all statements made in or out of court, and regardless of the motive for which they were made. This legal protection creates an insurmountable barrier to Lively's defamation claims against Friedman. His statements defending his client, whether made in court filings or media interviews, fall squarely within the scope of this absolute privilege. The privilege exists precisely to ensure that attorneys can zealously advocate for their clients without fear of personal liability for their advocacy efforts. Baldoni's legal team has characterized Lively's pursuit of discovery related to these privileged communications as aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. This assessment appears legally sound given the well-established precedent protecting attorney communications in the context of litigation. The broader implications extend to the ethical obligations attorneys face when their clients are subjected to public attacks. Friedman's media appearances can be understood as necessary defensive measures to counter what he perceived as a coordinated media campaign against his client. The timing of these appearances, following judicial dismissal of most counterclaims, suggests they were reactive rather than part of any proactive smear campaign. The characterization of Lively's subpoena efforts as harassing by opposing counsel reflects broader concerns about litigation abuse and the weaponization of discovery processes. The scope of Lively's discovery demands, reportedly encompassing over 107 individuals and entities, raises serious questions about proportionality and good faith litigation conduct. The court's recognition of the undue burden imposed upon Liner Friedman by the subpoena suggests judicial skepticism regarding the necessity and scope of Lively's discovery efforts. When discovery demands exceed what is reasonably necessary to resolve legitimate legal disputes, they risk crossing the line into harassment and abuse of process. Lively's argument that her subpoena was not unduly burdensome because her counsel had previously demanded that Friedman's firm cease and desist from publicly responding reveals a concerning strategic approach. This sequence suggests an attempt to silence defensive communications through legal intimidation, followed by discovery demands when that intimidation proved unsuccessful. The timeline is particularly revealing. Lively's cease and desist demand came days after Lively caused her allegations in her California civil rights complaint to be widely disseminated by the New York Times. This timing indicates a coordinated media and legal strategy designed to maximize public impact while simultaneously attempting to prevent opposing parties from mounting an effective defense. The Baldoni-Lively litigation represents more than an isolated celebrity dispute. It exemplifies broader concerns about the use of high-profile litigation as a public relations strategy and the potential for abuse of legal processes to silence opposition. The targeting of over 100 content creators and social media users raises particular concerns about the chilling effect such tactics may have on legitimate commentary and criticism. When litigation discovery is used to investigate and potentially intimidate individuals whose only connection to a dispute is their public commentary, it raises fundamental questions about the balance between legitimate legal discovery and the protection of free expression. The case also illustrates the challenges courts face in distinguishing between legitimate discovery needs and fishing expeditions designed to impose costs and harassment on opposing parties. The judicial system's ability to effectively police these boundaries directly impacts the integrity of the litigation process and public confidence in legal institutions. From a strategic litigation perspective, The case demonstrates the risks inherent in building legal theories around narratives that cannot withstand the scrutiny of sworn testimony and documentary evidence. Lively's apparent admission during deposition that her knowledge of alleged smear campaigns was limited to legitimate legal counterclaims fundamentally undermines the foundation of her broader allegations. The recent developments in the Baldoni-Lively litigation suggest that Lively's smear campaign narrative is facing systematic deconstruction through the normal operation of legal processes. Her own deposition testimony appears to contradict her public allegations, while the legal framework surrounding attorney privilege creates substantial barriers to her defamation claims. As this case progresses toward its scheduled March trial date, the focus will likely shift from the original allegations to questions of litigation conduct and discovery abuse. The court's handling of these issues will establish important precedents for how similar cases are managed in the future. The broader implications extend beyond the immediate parties to encompass fundamental questions about the balance between legitimate legal advocacy and the potential for litigation abuse. The resolution of these issues will have lasting impact on how high-profile disputes are conducted and the protections available to individuals caught in the crossfire of celebrity legal battles.